All right. Thank you so much, Britta and James and Taylor. So, good morning, good afternoon, and good evening, everyone. My name is Yuemin Yan. I am assistant professor from Chinese University of Hong Kong. I'm very delighted to be co-moderating today's session together with my co-chair, Professor Devlin Mick. From Chongqing University. So this session actually marks the third session in a new webinar series jointly organized by the Asia Pacific Interest Group as well as the ASO Task Force on ISDS and Climate Change. So as many of you may know, we have a pending proceeding before the ICJ on the obligation of states under international law to address climate change, one of the most urgent and complex issues facing the global community. So there are already more than 100 countries and organizations participating in the proceeding and the public hearings in December 2024. So today's session will be focusing on the preliminary reflections from the Asia Pacific perspective, a region we believe that not only faces serious risk from climate change, but also played a key role in advancing this proceeding. So our discussion will explore how states and legal experts from the region are engaging with the proceeding and what broader implications may emerge for international environmental law and climate justice. So I will now hand over to the co-moderator who will be introducing the topic and guide us through today's discussion. So if our participants have any questions, please use the Q&A function in this Zoom. David?
Thank you very much, Yumi. Tonight, to discuss the ICJ advisory opinion, we have invited three experts on the matter. First, we have Benoit Meyer from the University of Reading. He is professor of climate law, has published multiple books and articles on the topics, including his most recent 2022 book, The International Law Obligations on Climate Change Mitigations, which was published with Oxford University Press. Our next speaker will be Margaretha Wewerinke-Singh, who is Associate Professor of Sustainability Law and co-founder of Seven, the university's climate institute at the University of Amsterdam in the Netherlands. And finally, we would also welcome Professor Yukari Takamura, who is professor at the Institute for Futures Initiative at the University of Tokyo in Japan. Over the next about 30 to 40 minutes, we'll hear from each of the three speakers on several matters concerning the ICJ advisory opinion. We'd first like to begin with Professor Meyer, Benoit. And we'd like to ask, well, could you give us a little bit of background on the ICJ climate change advisory opinion and what's its relevance for Asia Pacific states, generally speaking? Benoit, I'll pass the floor off to you.
Thank you very much. I trust you can see my screen. So thank you very much for inviting me. It's a great pleasure to see many of you, my friends from different continents. So I will speak about.
Sorry to interrupt. We cannot see the screen that you're sharing. Sorry.
Oh, let me try again.
Okay.
I converted to MS Teams. So I'm not really used to Zoom anymore. Can you see it now? Yeah. Okay.
Yes, we can see it now. Perfect.
I know it because I can't see you anymore. Okay, so I will speak about kind of introduction to about what this advisory proceeding is and what is really at stake, and what is at stake specifically for Asia Pacific countries. As a kind of a background, so there have been negotiations on climate change for above more than a quarter of a century. 3 treaties have been adopted: the UN Framework Convention on Climate Change of 1992, the Kyoto Protocol, which is kind of history, of 1997, and the Paris Agreement of 2015. But those treaties have important limitations in terms of ambition, in terms of participation, with the possibility for states to withdraw, as we can see in the US, and in terms of compliance. Even if a state is participating, they may not want to comply, or there's not much enforcement possibility. And those issues compound one another. The possibility of withdrawal makes it more difficult to have ambitious treaties because states might not participate or may not stay in the treaty. And so those limitations have led people to think about, are there sources of obligations on climate change beyond climate treaties. And those could be under customary international law, they could be under human rights treaties or under environmental treaties as well, in a sense that climate change affects the enjoyment of human rights and affects the quality of the environment, and therefore you might interpret the obligation to protect human rights or the environment as an obligation to mitigate climate change or to adapt to its impacts. There has been a strong increase in number of cases on climate change, mostly before domestic courts. I'm not going to give any numbers here because the concept of climate litigation is not well defined. You have different ways of approaching it. But there are some core cases that aim at identifying, interpreting, and applying obligations of states, mostly, sometimes corporations, to address climate change. And those cases may be about mitigation, that's reducing greenhouse gas emissions, mainly with the view of mitigating climate change as a global issue. They can be about adaptation, that is about dealing with the impacts of unavoided climate change at a local scale, mostly. And they can also be about reparation, trying to claim compensation or some kind of responsibility or liability from states or corporations responsible for causing climate change. Most of the climate litigation so far has been before domestic courts, but there has been a tendency to bring it to a supranational level. There have been cases before the European Court of Human Rights, and there are now 4 cases for international advisory proceedings before international courts as well. Before looking at those, just some kind of highlights here. What is really the core of climate litigation? Here I have 3 kind of outstanding court decisions that are, they're not examples of a trend. They're really the outstanding cases. The first one is the case of Uganda against the Netherlands. Before the Supreme Court of the Netherlands, the court interpreted the European Convention on Human Rights as the source of an obligation for the Netherlands to reduce greenhouse gas emissions by 25% by 2020 compared with 1990. The second case was decided last year by the European Court of Human Rights. Wewerinke-Singh, an NGO, claimed that Switzerland was not doing enough to reduce their greenhouse gas emissions, and the European Court agreed, based, among other things, on the fact that Switzerland did not have a clear carbon budget. And so the court found that the state was not taking the necessary steps to mitigate climate change. And the third case is an advisory opinion by ICLOS. It was requested by the Commission of Small Island States on Climate Change and International Law. And ICLOS confirmed the interpretation of Part 12 of UNCLOS on the protection of the marine environment as the source of an obligation to mitigate climate change. And ICLOS also explained that this obligation under UNCLOS may go beyond compliance with climate treaties. So it's a very kind of quick overview of climate litigation. Now, why have people and courts and states turned to advisory proceedings? And how? So the idea is not new, right? In 2011, you had a short-lived campaign by the small island state of Palau in the Pacific to request an advisory opinion from the ICJ. That was not successful, and the campaign was interrupted very quickly. People say that this might be because of some pressure from the US. Palau receives a lot of international development aid from the US. I have not seen any evidence of that, but that seems a likely scenario. Later, about a decade later, there has been a renewed interest with a growing frustration with international negotiations, the pace, the outcome, and the focus of those negotiations, the lack of discussions on reparation in particular, have led some people to look at other forums to implement ambitious action on climate change. There's also been an increasing awareness of climate change and its impact. So why advisory proceedings then and not contentious proceedings? There have been discussions, of the possibility of Tuvalu suing the US, something like this before the ICJ. There are, of course, jurisdictional and admissibility questions, but advisory proceedings have this advantage of being polycentric. They allow multiple states to put their view. So it's perhaps a more appropriate kind of proceeding for addressing an issue like climate change, which is not an issue between two states, but it involves the entire community. There have been strong political obstacles to requesting an advisory opinion before the ICJ. In particular, you will need a decision of, for instance, the General Assembly to be adopted by the majority. That seemed impossible a few years ago, very unlikely, and suddenly all of this changed 2-3 years ago. There are now 4 advisory proceedings before international courts. The first one, ICLOS, that has been decided last year, as I mentioned before, was requested by an ad hoc organization. Ad hoc in the sense it was created for that purpose in 2021 by Tuvalu and Antigua and Barbuda. That advisory opinion was focused on part 12 of UNCLOS because it was before ICLOS, right? A few months after the request by COSIS, you had a request for an advisory opinion before the Inter-American Court of Human Rights that was filed by Chile and Colombia. And so here the focus is on the American law on human rights, in particular the American Convention on Human Rights, but possibly also some other treaties applicable to American states. Then you have the advisory opinion that we are discussing here today before the ICJ, which is perhaps the most important, the most influential likely, that has been requested by consensus by the UN General Assembly with 132 co-sponsor states at Vanuatu's initiative. Why did states suddenly accept to file the advisory opinion? I think this has a lot to do with the 2 other proceedings. Something was going to happen anyway, and bringing it to the ICJ was perhaps a way for states to have a bit more control on it, to avoid the Inter-American Court going wild in isolation from the ICJ. So the ICJ was perhaps seen as a preferable forum to some of the other forums that in any case will have to decide on those issues. And also the ICJ case, unlike the others, looks at general international law generally, including customary law, human rights treaties, and environmental agreements. And on Friday last week, a 4th advisory opinion has been requested before the African Court of Human and People's Rights by an NGO, the Pan-African Lawyers Union. So now you have actually a 4th advisory proceeding starting. The questions before the ICJ, well, there are 2 different questions. The first one is about the obligations of states to ensure the protection of the environment from greenhouse gas emissions for states and for the present and future generations. So that will be mostly about climate change mitigation. And there is an interesting concept of future generations in this question as well. The second question is a bit, beyond that, is what happens if states do not comply with the obligations in the first question? What are the legal consequences under these obligations for states where they have caused significant harm to the environment with respect to states or to people and individuals for the present and future generations? So you have, I think, essentially primary and secondary obligations in those 2 questions. What are the underlying issues? What do we expect the ICJ to decide, and how do we expect the court to develop international law? I think that the first question will be, the first really important issue will be for the ICJ to confirm that climate treaties are not the only shop in town, that they do not prevent the application of other sources of international law. I think ICLOS has already decided that. It's very unlikely that the ICJ will find otherwise. However, a number of states have actually argued before the ICJ that climate treaties form a form of lex specialis. I think that's very unlikely because there is no contradiction between climate treaties and other sources of international law. So there is no real conflict. And so those sources can coexist and should therefore, all of those sources should apply at the same time. The second kind of important issue is that, okay, if other sources of international law can apply to climate change in addition to climate treaties, what are those sources and what is the content of the obligations under those sources? Here, the court will have to decide what customary international law applies to climate change and what is the content of this customary law. The court will also have to discuss whether human rights law applies and what might be the obligations towards future generations that may apply. The third type of big issue would be like state responsibility for breach of those obligations. When you have 190 plus states emitting and 190 plus states affected to a different extent, the issue of responsibility becomes extremely complex. And I think the kind of underlying issue is really how will a court deal with such deep normative indeterminacy? Those questions are not easy. They are not yes or no questions. They have not been settled by over a quarter of a century of very intense negotiations. I don't really know how the court can deal in details with the content of an obligation of states to mitigate climate change under customary international law, for instance. What would be the potential output? So there is a possibility that the court, the ICJ, may decide not to deliver an advisory opinion. Right? It's a theoretical possibility. I think it's extremely unlikely, but the ICJ statute says that the court may deliver an advisory opinion. What's likely more likely is that the court may give an advisory opinion, but not really answer the questions. It could be that the court is just unable to reach an agreement. The court has to agree on by a majority vote on any decision. And when you have an open question, a majority vote is not always a possibility. Right? It's not a yes/no question. It's an open question, and there are more than two possible answers. There may be a non-liquid, a finding that the court cannot answer the law, formal or informal, an implicit non-liquid, as we have seen in nuclear weapon advisory opinion, where the court said we can't really give you a definitive answer. It might also be that the advisory opinion seems to answer the question, but does not really answer the underlying issues. And we have seen that in Western Sahara and in the Kosovo advisory opinion, where the court formally answered the question, but the question was not properly asked, and therefore the court did not really address the issue. If the court does answer the question fully, we could have what I call an identificatory opinion. It would be just, that's the sources, those sources apply, so those are the sources, and that's it. Or the court could go further and could try to interpret the obligations, saying, okay, what does that mean to have a due diligence obligation? Or the court could even go further and try to apply those obligations, and for instance, in the most radical way, adopt some kind of tables with the list of states and the list of emission reduction percentage they should achieve by a given timeline. This is very unlikely as well. If you look at the ICLOS advisory opinion, which is the only one we have so far, it was really focused on the identification with a little bit of discussion about the interpretation, but the ICLOS said those obligations are very stringent. That was not really saying much about the content really of those obligations. What about the potential outcome? What will come out of all of this? It's not really clear. I mean, what will be the effect on states? Will states comply with the advisory opinion? What will be the effect on international negotiations? It may an advisory opinion that contains a lot of ambitious language may reinforce the position of the countries asking for more ambitious action, but it may also create some kind of allergy on the side of the other countries, and you may have less participation, for instance. So there may be like unintended impacts on negotiations as well. Another question is what would be the effect on international law? An advisory opinion that is very ambitious and not implemented, or a refusal of the court to give an advisory opinion that is viewed by some people as unfair, could erode the credibility of international courts and international law generally, and in a very perverse effect that could also impede the implementation of climate law, which relies on international negotiation, on the credibility of international law. So what is the relevance of all of this to the Asia-Pacific region? As a caveat, I'm not really a strong believer in something called the Asia-Pacific. I think that includes half of the world, 2/3 of the population of the world, very diverse countries in terms of income, in terms of culture, and so on. So what all of this means for Asia-Pacific really depends on what bit of the Asia-Pacific you're looking at. there will be potentially an effect on greenhouse gas emitters, including large greenhouse gas emitters like China and India increasingly. But also on smaller countries that are, smaller and therefore smaller greenhouse gas emitters, but also rely heavily on greenhouse gas emissions. And that, thing we tend to forget, includes a lot of small island developing states. The Maldives, for instance, relies heavily on long-haul tourism. Those emissions are not accounted for by the Maldives because they are international aviation emissions. But I mean, some of those island states also benefit a lot from greenhouse gas emission. And if you were to decrease those emissions, those countries will also be affected. What will be the effects on emissions? Then, I mean, if the advisory opinion does reduce greenhouse gas emissions, it will, be an advantage for the most vulnerable countries. And again, I mean, it's not really straightforward what those countries are. That may actually include some developed countries as well that are potentially very affected by climate impacts. The enhanced efforts to mitigate climate change may, of course, help to reduce the impacts of climate change. And then there could also be an impact on the redistribution of resources. If you have if you have a clearer obligation to adapt or to mitigate climate change and a clearer obligation to assist other countries, then there would be potentially more assistance funding, international funding for adaptation, for mitigation as well, and potentially reparation. And I think that's also an important stake for some countries. Small island developing states, which have been quite active in bringing those cases, tend to have a relatively important share of international development aid as part of their GDP. So they may actually benefit also quite a lot from this kind of redistribution of resources. So that's it for my very short overview. Thank you.
Thank you very much for providing that kind of historical overview. Noticing that we now have this new climate change advisory opinion that we'll also be keeping an eye on, and kind of highlighting some of the possible outcomes. Whether we actually get an advisory opinion or not is actually in question. So I would like to move on to our next panelist, Margaretha, who had represented Vanuatu in the ICJ advisory opinions. We'd like to ask if you could just offer some reflections on Vanuatu's experience in the ICJ advisory opinions, its relevance for Vanuatu, and your experience representing Vanuatu. Thank you very much. Margaretha, we'll pass the floor on to you.
Thank you so much, David, and thanks to all of you for organizing this this conversation, which is indeed timely as we are preparing for not only the ICJ advisory opinion to be released, but also the Inter-American one, and looking forward to a whole new set of proceedings before the African Court on Human and People's Rights. So I'll keep it very brief. This story could be told and has been told in much detail, but for the purpose of today's webinar, let me highlight how this initiative has come about, and particularly the role of youth in the birth of this initiative. And also I'll talk a little bit about the pre-request stage, so how the request came about in the UNGA, and then I'll talk a little bit about the legal proceedings before the ICJ itself in the Peace Palace in The Hague. So as many of you will be aware of, the initiative to seek an advisory opinion from the International Court of Justice on climate change is not new, as Benoit noted. It was, well, it dates back to even the time prior to the adoption of the UN Climate Convention, when it was already talk about state responsibility and the role of general international law. But it really resurfaced in earnest in 2012, and Palau seriously considered requesting such an advisory opinion and started to build a coalition with several states already confirming to join from different regions. But indeed, that initiative did not in the end persist. Palau dropped that idea, and then it was only in around 2018 when this new attempt that ultimately was successful was launched. And so I think the onset of it was really a natural or unnatural disaster that hit the Pacific, particularly Vanuatu in 2015, a Category 5 cyclone that was very destructive. And for Vanuatu, that was really also a confrontation with its own vulnerability and the severity of the threats, because the cyclone was so destructive that it was clear that with increasingly severe cyclones, and especially in the absence of dramatically increased international support to address these kinds of impacts, that the country risked becoming essentially unviable or uninhabitable. So 2015, as we're all aware, was also the year in which the Paris Agreement was adopted. So I had the privilege to be part of the Vanuatu delegation in Paris, negotiating the Paris Agreement with a group of students who were assisting Vanuatu and other Pacific Island states. And but clearly, some victories, I think, were achieved for the Pacific and other climate vulnerable states, in particular the clear inclusion of the 1.5 long-term temperature goal as opposed to just 2 degrees, and then the inclusion of a standalone article on loss and damage, that Article 8. Prior to the Paris conference, there was an almost successful attempt to keep that issue off the agenda. Literally, it was not on the agenda in Paris in an attempt to try and avoid it being included in the Paris Agreement, but it was essentially the climate vulnerable states agreed jointly to make it a red line in their negotiations. And so the inclusion of Article 8 was ultimately achieved. But of course, one doesn't need to be very or have tremendous expertise in climate law or international law to see that these provisions are ambiguously framed, and also if you look at their effect in the real world, then there is room for some disappointment, if not skepticism, about what these treaties accomplish in practice. And of course, as Benoit also noted, these treaties like this are vulnerable to being abandoned, as just happened again with the United States abandoning the Paris Agreement. And so already at a time it made sense to look at other options. That was what the Vanuatu government did. And in parallel, students at the University of the South Pacific, law students from across the Pacific Islands region, were asked during a class of international environmental law, actually as part of an extracurricular assignment, to think about options for essentially achieving climate justice or addressing this climate change problem through international law. And so students carried out a kind of mapping exercise, looking at all the different pathways and mechanisms that existed, and came to the conclusion that the most promising action that could be taken would be to bring this matter before the International Court of Justice by invoking its advisory jurisdiction for a whole range of reasons, including some that Benoit already touched upon. But essentially for the Pacific, it was attractive that it's not a confrontational approach. It's collaborative, and that lends, it's not only diplomatically beneficial to do that, but also that lends legitimacy to the initiative. So the request, it was soon decided would need to be made through the UN General Assembly. So that means that you really have essentially the UN, so you can say the vast majority, at the very least, of states making the request to the highest court in the world. So that became a campaign slogan. We need to bring the world's biggest problem to the world's highest court. The campaign initially centered on the Pacific. So the students petitioned their own leaders in the Pacific to put it on the agenda, first at the Pacific Islands Forum. And there it was initially somewhat cautiously embraced, and later on much more clearly and expressly in the outcomes of the leader summits of the PIF. And Vanuatu was the government that ultimately agreed to champion it, also at the UN level. So the pathway was clear. The UN General Assembly would need to be adopted, and then the requirements for the adoption of a resolution requesting an advisory opinion from the ICJ are somewhat unclear, but the most common interpretation of the rules is that a simple majority was needed to get it through. So that means at least a very good number of UN member states would need to be on board. And Vanuatu, initially with very limited diplomatic capacity, just one ambassador running the embassy in New York, needing to convince all UN member states to come on board with this initiative. Vanuatu built the coalition cleverly, essentially using a strategy of concentric circles. So first socializing the initiative in the region, and then expanding to the Caribbean, to other SIDS, going to the OACPS, the Organization for African, Caribbean, and Pacific States, with 79 member states. And when the OACPS came on board, I think that moment was really a game changer in the campaign, because it signaled that Vanuatu had the numbers. And at that point, the mission in New York had already started to form a core group that's often around a proposed UN General Assembly resolution. A core group is found, a cross-regional group, memberships from all the different regional groups of the UN. And that core group then negotiates the text, and then is also informally responsible for securing support from the respective regions. So that core group was formed here also as to negotiate the text of Resolution 77-276. So that's the ultimate number that it would get. And that the bulk of the hardcore tough negotiations on the text happened within that core group. And it was only once the core group was on board for the text that the rest of the UN membership was then consulted, and several informals were held. But that text was then pretty much, the core of it was agreed upon. So some modifications were made to try to accommodate as many positions as possible, but it was really the core group where the key issues were hammered out. So Vanuatu's role in this was not just to secure support for the idea of an ICJ advisory opinion, but also really to propose a text and to design and advance the legal strategy that would ultimately shape the request, and then also part of the opinion. So in the negotiation stage, it was really about the framing of the question. And for Vanuatu, it was important to ensure that the question captured the question also of accountability for the consequences of climate change, and not only that it wouldn't be only forward-looking about what states need to do to prevent further harm, but that it would also help enhance accountability for impacts that have already occurred. In other words, the Vanuatu wanted to secure an opinion that would have a broad temporal scope, looking at past, present, and future conduct and related harm. So that is reflected in the formulation of the question as it is. The negotiations were tough because essentially to simplify the complex dynamics that played out there in New York, historical polluters wanted to see a purely forward-looking question, and thus opinion wanted to ensure that the court would not address historical emissions and historical responsibility. And so ultimately, a compromise was achieved by a split question. So if you look at the questions A and B, then question A is essentially the question that the global north would have preferred. And then question B is a question that the global south, and again, I'm simplifying, of course, very broadly speaking, these were the dynamics. This question B about legal consequences was the global south driven question. And so the compromise was to have both. And ultimately, once the core group was behind it, consultations were held. It even, to, I think, the surprise of many, the resolution was adopted by consensus rather than a vote. So it's the first time for the UNGA in its current, with its current membership to adopt an ICJ advisory opinion request resolution by consensus. Then, well, as we all know, the initiative moved to The Hague. Proceedings happened. I'll just say a few words about Vanuatu's role there. So, of course, technically speaking, Vanuatu is just one amongst all the other UN member states who have requested the opinion. It was UNGA that requested the opinion, not Vanuatu. But it was recognized that Vanuatu played a special role. Vanuatu did that in practice by providing guidance to many participating states, from logistical support to many Pacific states and other small states that had never participated in ICJ legal proceedings, to technical support on trying to explaining the question and what was at stake and potential strategies, etc. Also, ultimately, Vanuatu was granted the privilege to speak first in the speaking orders, was the first to address the courts during the hearings. Now proceedings have closed, and we are in a waiting mode, so to say, curiously anticipating the opinion, but of course at the same time also getting ready to ensure that the opinion has an impact in practice. And so one of the steps that we know needs to be taken is the adoption of a resolution by the UNGA welcoming or endorsing the opinion. That's the common practice after an advisory opinion is delivered. And so discussions have commenced about the text of that resolution. What should the UNGA call for? It can be anything under the sun almost, from a simple acknowledgement of the opinion to very concrete steps to implement specific parts of the opinion. And so there's interesting precedents that we are looking at as sources of inspiration for those next steps. I'll leave it at this, and very much look forward to hearing your comments and questions.
Thank you very much for the discussion on Vanuatu's pivotal role in the ICJ advisory proceedings from the beginning until now, and as an ongoing, as you mentioned, the possible UNGA resolution after an advisory opinion. We'll move on to our final speaker of the night. Yukari, you have participated in the proceedings on behalf of Japan. And I was wondering if you might also be able to offer some reflections on Japan's participation in the climate change advisory opinion proceedings. The floor is yours.
Thank you, David, and also together with the human. It's wonderful to be a part of this webinar, especially I think this advisory opinion is very much attracting the global wide interest from the academic, the working in the environment and climate. So I think already the previous speaker covered quite, the substantively, so that I just pick up my comment on this couple of points. So the first, that is, as you know, the request on the advisory opinion. First point that I like to say is that the formulation is really focused on the general obligation of state and its legal consequence in case of violation or non-compliance of these state, so that in my impression that the proceeding or the focus on heavily on the general obligation of state, especially to prevent transboundary damage to the environment, or no harm, or the principle of prevention. So of course, it is not our governmental position. It's just my own opinion. It's an obligation of state to prevent transboundary damage to the environment. Of course, it's well-established customary rules. I think no one denying it. And also interconnection between the obligation and the duty of due diligence is of course, we can date from the PubMed case, and also most recently the Ichiro's advisory opinion also confirmed that the principle prevention has its origin, its due diligence, and also this state then obliged to use all the means at its disposal to avoid activity, blah blah blah. So the problem in the context of climate change, I understand that there is no special or specific standard of due diligence is clarified or identified. Just Ichiro's advisory opinion last year, the standard of due diligence, of course, the vary depending on the particular circumstances to which obligation due diligence apply. It's quite well known. And also they cite the several factors to be considered when we, the judge or determine the due diligence standard are met or not. So here you can see that scientific technological information and the risk of harm and the urgency involved, and also here the relevant international rule and standard. Now, of course, the state capability and availability of resources is also one of the factors to be considered. As the Professor Benoit mentioned, that I think one of the maybe one very big point for the International Court of Justice this case is that the relation between the climate treaties and such kind of general obligation of state. So the more specifically, or maybe go beyond the formulation. Some say that Paris Agreement and the UNFCCC lex specialis, and then they override the general obligation of state, and then that's so or not. I think that is, I think quite one of the big legal discussion point. In my sense, I don't think so, but I wish to know that which other panelists think. Especially the Paris Agreement even have less clarity. Not well actually they stipulate everything relating to what's the general obligation of the state in this field covered. But still, as I say, that the Paris Agreement element, especially the state obligation, is a very important factor to be considered, very much in line with the previous International Court of Justice and ITLO's advisory opinion. For instance, here I don't need to repeat every 5 years NDC and that do all effort to pursue domestic mitigation measures, and they increase the progression, a level of ambition over time, and reflect its highest possible ambition of the state. And also the last point is that, as you know, that NDC should be informed outcome of the global stake. It should be actually consider and assess the collective progress toward achieving the purpose of the Paris Agreement, including its long-term goal, here the 1.5-degree goal. So that is one point. The second point is legal consequences. I personally think that still there are some room to be worked for the general obligation state, even though there are the Paris Agreement and the UNFCCC and other such specialized international rule relating to the climate change. But still, as already the ITRA's advisory opinion suggested, that given the diffuse and cumulative cause and global effect of climate change, state responsibility scheme especially may not work effectively. I just take up example, and Japan, not only Japan, the Asia Pacific region is one of the largest emitting region, at the same that the one of the most vulnerable region, facing the climate change adverse impact. We had a very big damage, especially the heavy rainfall and the typhoon. This is a case of the typhoon, one of the typhoon in 2019. The climate science suggests that actually 40% of the damage caused, due to climate change. But the problem is that this exact damage actually incurred by which country and which part, and then 60% due to natural causation, which part this part is how to cover it. So that is one of the difficult. I cited one example as how it's quite difficult to make the state responsibility scheme work. So the last, I think, just they raise a couple of points. I mean, beyond the maybe ICJ advisory opinion, whatever it is, and one is how to strengthen state action. I think every country recognize that necessity, and also every country, no one denied how important the Paris Agreement, UNFCCC. So how to then strengthen state action in the forum of these climate regime, and maybe other forums such as regional one specialized in the Asia Pacific region. Second point is that maybe it's not a secondary status in the advisory opinion, but the human rights law, as Professor Benoit mentioned, that I think we might have a chance to strengthen the state action obligation in collaboration with human rights law, especially already some jurisdiction making use of the clarifying, identified what is the state obligation to protect the individual from the threat to the life and privacy. It's, I think, how to then make more clear the obligation of state in the field of the human rights protection. The last is corporate. It's just come from the World Bank. The report that the 160 corporate emission actually relevant to the more than 60% of industrial emission from the industrial sector. So how to then we can have a kind of strategy to strengthen the corporate action by making use of, again, this possible in the ICJ climate advisory opinion. Thank you.
Thank you very much. As we are quickly coming to a close, I will thank all of our speakers for your timely and interesting presentations, and ask that you all come back and turn on your cameras for the Q&A session. We have a question that is coming in, but for those of you who are in the audience, if you would have a question or a comment, please use the Q&A function to type it in there, and I'll present it to the speakers. If you would like your question directed to a specific panelist, please indicate which panelist you would like me to direct it to. We have one question. I wanted to ask, to what extent were the rights of future generations and the principles of intergenerational justice reflected in the arguments presented during the hearings? Can the ICJ advisory opinion help strengthen or expand the rights of future generations and the principle of intergenerational equity? Now, this is not directed to any particular panelist, but I think I might direct this to Margaretha. As you had mentioned, this kind of dual nature of intergenerational equity and future generations. You even mentioned that the questions were kind of preferred by Global South, Global North. I think maybe if you have any reflections on that question, on the topic of intergenerational equity.
Yes, it's a great question because, of course, intergenerational equity features substantively in the questions, in both questions, actually. So this is an area where the Global North and the Global South seem to converge, at least in agreeing on the relevance of the principle, maybe not on the exact interpretation of it, but in any event, both intergenerational and the notion that future generations are rights holders under international human rights law were raised during the proceedings by several participants in different ways. The Maastricht principles on the rights of future generations, of which, full disclosure, I'm a co-author, were also cited by several of the participants, also from different regions. And so there are different ways in which the court could draw upon future generations' rights and or intergenerational equity for the interpretation of the state obligations under the first part of the question, but also for determining what the legal consequences are of breaches of obligations, because such secondary obligations could also be owed, of course, to future generations. So it would be, I think, very surprising if the court would be completely silent on this question, and the extent to which we'll see a very detailed interpretation remains to be seen.
Thank you very much. We have another question. I think I'll pass this one to Benoit. So you had mentioned that there's these 3 other advisory opinions. We have the ITLOS, we have the Inter-American Court of Human Rights, and we have the African Court of Human Rights. Kind of what's going on in those other advisory opinions, and how might those advisory opinions impact or be reflected in the outcome from the ICJ advisory opinion?
Right, thank you. So I think a lot of the question is about the timing of the decisions. So the ITLOS advisory opinion is already delivered. So it's the first. The Inter-American Court might be the second, or maybe the third. They kind of parallel with the ICJ in terms of timing. Both of them have completed the oral proceedings, and it's just under deliberation. And then, of course, the African Court, they will need a bit more time, obviously, because they just started last week. Most of the time, I think courts don't really want to contradict each other, right? So what a court has said first, the other court will very likely take for granted. That's why we don't really expect the ICJ to come back on the lex specialis argument, really, because ITLOS has already kind of put it aside. And so here, I think the big question I really have is which one comes first, the Inter-American Court or the ICJ? Because the Inter-American Court has a tendency to go quite far in the interpretation of human rights law. So if the ICJ comes first, it might be a bit more conservative as an outcome. If the Inter-American Court comes first, Well, of course, they would try to limit what they're saying to try to avoid the ICJ being in an awkward position, but that might lead to a more expansive interpretation of international law. Just coming back also to the previous question, I think there's also something to say about the amount of materials. I'm not sure if we really reflected that in our presentations, but I just checked now. I have 4.3 gigabytes of documents downloaded from the ICJ's website. I didn't check how many pages that is, but that would be in the tens of thousands of pages. This is insane amount of materials. Nobody can read all of this. So that also means that courts cannot work in the way they normally work in this kind of circumstances when you have 100+ countries submitting written submissions. So that's also a very important challenge. Thank you.
Thank you very much. Our next question goes to Yukari. We have a commenter who has mentioned the European Union's Corporate Sustainability Due Diligence Directive and asking maybe how can we use these kinds of due diligence, or if you have any reflections on the due diligence directive, and how it might interact with the advisory opinion in climate change law.
Yeah. Thank you, David, and thank you for your question. Actually, the due diligence for the corporate level and due diligence at the state level is not really the same, but still if the ICJ deliver a kind of a necessity or recognize a necessity to strengthen the climate action. That I think I'm quite sure of that. But that should be one of the state, how can I say that the option that the state could do in collaboration with other countries as well. So we understand that not only CSSD, but also the corporate sustainability reporting is the expanding, not only Europe, but also in Asia Pacific region. So that the how to then mitigate the emission is, I think, of course, the state responsibility, but the state could regulate the action and by the corporate. So that I think it's one of the topic that the Asian Pacific region also could collaborate. Thanks.
Thank you very much. I think we have maybe time for one last question and a very quick response. In your experience and opinion, how impactful do you think the indirect effects of the ICJ case are? So, for example, the ability to platform victims and their story, generate awareness, build coalitions and consensus, and how do we measure success in this kind of impact? And I think I'll pass this to Margaretha, as this is something that you directly dealt with in your presentation, for a very brief, maybe 1 to 2 minute response. Thank you.
Yes, that's a really great question, because it reminds us of the importance of not just thinking about the law and formal legal impacts, but about impacts more broadly. And to some extent, I think we can say that for the ICJ initiative, significant impact has already been achieved, where I think it can be very inspiring for especially young people around the world to see that students can, in any classroom, even in a region that is relatively peripheral in terms of location and resources and so on, an idea can be brought to life and result in a UN General Assembly resolution and ultimately a case before the International Court of Justice. So that example, I think itself is inspiring. Of course, several students have actually been pleading before the court. Their voices have been heard. So that is an impact that hopefully will inspire also more inclusive approaches to international law and more fresh ideas to use the international legal system to advance justice.
Thank you very much. So thank you all to our speakers. Thank you all to the participants. Thank you to the American Society of International Law for assisting in the organization of this event. This has been a wonderful discussion, something that we as Asia Pacific Interest Group are hoping to continue working on with the ISDS and Climate Change Task Force. So please look out for future events. Please look out for other Asia Pacific Interest Groups events. We have 2 other webinars in the works, one on the suspension of the Indus Waters Treaty between India and Pakistan, and another on tariffs and their impact in the Asia Pacific region. So thank you all very much for your participation. Thank you for this excellent discussion. And we will conclude this session and hope to see you all soon. And really looking forward to the upcoming release, perhaps in the next few months or in the next year, of the climate change advisory opinion from the ICJ. And maybe we'll have to reconvene you all to have this discussion once again, once we have that out. So thank you.